November 12th, 1946. A folder drops onto a polished oak table in Nuremberg. Inside, 47 photographs, 9 sworn affidavits, and 300 pages of typed medical reports. Within 6 months, 4 physicians will be sentenced to hang for what's documented in that folder. Not for combat, not for orders they followed under fire, but for experiments they designed, approved, and expanded at Dachau concentration camp between 1941 and 1944. Most people think they know what happened at Dachau. Starvation, executions, the machinery of the Holocaust. But what the tribunal uncovered was something different, a parallel system, clinical and systematic, where prisoners weren't just murdered, they were measured, where death certificates included autopsy findings, where suffering was quantified in charts. The question isn't whether crimes occurred. The evidence made that impossible to dispute. The question is, what specific moment in that courtroom made the judges realize that prison sentences weren't enough? That some acts require the ultimate penalty? Because something shifted during those proceedings. A single exchange, one piece of testimony, a detail so damning that it collapsed every defense strategy and transformed a war crimes trial into a death sentence hearing. I'm going to walk you through exactly what that moment was, why it mattered legally, and how it created the framework protecting every medical patient alive today, the Nuremberg Code. Informed consent, ethics review boards, every safeguard you encounter in a hospital exists because of what prosecutors proved in that room when they opened files marked Dachau medical experiments. 1941, 1944. You'll see how doctors turned medicine into torture, how the Third Reich built infrastructure around it, and how one prosecutor's strategy exposed a truth so undeniable that execution became not revenge, but necessity. Before we go further, if deep dive historical analysis using primary trial documents is your kind of content, I'd appreciate you hitting subscribe. It tells me you want more like this, and it helps the channel grow. And as we move through this story, drop a comment. Where's the line between wartime medical necessity and murder? I read every one. Dachau opened in March 1933, 12 years before American forces found it. Originally designed for political prisoners, communists, socialists, dissidents. By 1939, it had expanded into a sprawling complex holding over 30 Zollverein prisoners from across occupied Europe. But in 1941, something changed. SS leadership identified Dachau as suitable for special research projects. The rationale was straightforward. The camp had infrastructure, medical facilities, and an unlimited supply of subjects who, in the Reich's view, had no legal rights. The first proposals came from military medical officers facing practical problems. Luftwaffe pilots were dying in high-altitude bailouts. Soldiers were freezing in Arctic deployments. Battlefield medicine couldn't test extremes ethically, but concentration camps could. Dr. Sigmund Rascher, an SS physician and Luftwaffe researcher, wrote directly to Heinrich Himmler in May 1941 with a proposal. Let him use prisoners to test human limits in low-pressure environments, simulating high altitude. No volunteers, no safety protocols, just data. Himmler approved within weeks. Between 1941 and 1942, Rascher conducted nearly 200 high-altitude experiments at Dachau. Prisoners were placed in low-pressure chambers replicating conditions at 68 degrees over 0 feet. Most lost consciousness. About 80 died. Rascher documented everything. Time to blackout, convulsions, the exact moment respiratory failure began. He presented findings at a military medical conference in October 1942. Colleagues asked technical questions. No one objected. Encouraged, Rascher proposed a second series, cold water immersion experiments, testing survival times in freezing conditions faced by downed pilots and shipwrecked sailors. Again, Himmler approved. Again, Dachau provided the subjects. Between late 1942 and May 1943, approximately 300 prisoners were used in freezing experiments. Mortality estimates vary, but tribunal records confirmed at least 90 deaths directly attributable to the tests. Now pay attention to how the system functioned, because this becomes critical in court. Prisoners were selected by camp administrators, usually political prisoners or Soviet POWs. They were told they'd been chosen for medical work duty, which often meant lighter assignments. Some believed it. They were brought to a designated building within the camp, isolated from the general population. Medical staff recorded baseline vitals, weight, temperature, pulse. Then the procedure began. Subjects were stripped and immersed in tanks of ice water, temperatures held between 36 and 54 degrees Fahrenheit, just above freezing. Cold enough to kill, but slow enough to measure. Some experiments tested survival time. Others tested rewarming methods. A few tested both, pushing prisoners to the edge of death, then attempting revival. The doctors measured everything. Core body temperature via rectal thermometer, time to unconsciousness, onset of cardiac irregularities, respiratory distress, muscular rigidity. Rascher's reports described prisoners shaking violently for the first 20 minutes, then going still. He noted the phenomenon clinically. Subject ceased voluntary movement at 34-minute mark, core temperature 84, 6 degrees Fahrenheit. Some died in the tanks, others during rewarming, their hearts unable to handle the shock. A few survived and were returned to camp barracks, only to be selected again weeks later for follow-up testing. What made this legally significant wasn't the brutality alone. It was the documentation. Rascher kept obsessive records. Each experiment had a file, subject number, date, water temperature, immersion duration, survival outcome, autopsy findings for fatalities. He took photographs. He created data tables correlating temperature with time to death. He graphed survival rates. Why such meticulous record keeping? Because he thought this was science. He genuinely believed he was contributing valuable research, data that would save German military lives. The prisoners weren't people to him. They were experimental variables, statistically useful, ethically irrelevant. That mindset, clinical detachment applied to murder, would become central to the prosecution's case. Because when investigators found those files in 1945, they weren't piecing together crimes from fragmented testimony and unreliable memories. They were reading signed reports from physicians describing, in precise technical language, how they killed human beings. Let me give you one example. Prosecution Exhibit 213. A report dated March 1943 describes an experiment on 3 Polish prisoners. All 3 were immersed simultaneously in water at 39 degrees Fahrenheit. The goal? Test whether group immersion affected survival time differently than individual immersion. Subject A remained conscious for 41 minutes, died during rewarming. Cause? Cardiac arrest. Subject B lost consciousness at 38 minutes, survived rewarming but died 6 hours later. Autopsy noted pulmonary edema. Subject C pulled from tank after 50 minutes. Rewarming attempt unsuccessful. Death occurred within 12 minutes. The report includes a typed conclusion. Group immersion does not significantly alter individual survival time. Variance appears related to subject body mass rather than environmental factors. 3 men dead, documented like a chemistry experiment. That report and dozens like it would be entered into evidence at Nuremberg. And defense attorneys would have no way to deny it, dispute it, or claim it was exaggerated because their own clients had signed it. But the documentation went deeper than individual experiment reports. It revealed a bureaucratic machine. Rascher didn't work alone. He didn't operate in secret. Every step required coordination, approval, resources, and that coordination left a trail prosecutors would follow all the way to the top. The experiments required equipment, immersion tanks, thermometers calibrated for extreme cold, medical monitoring devices, cameras for documentation, all of it requisitioned through official Luftwaffe supply channels. Procurement orders were filed, approved, shipped. They required personnel, medical assistants, camp guards to transport prisoners, administrative staff to maintain records, each person assigned through normal SS channels. They required funding. Research budgets allocated by the Reich Research Council, dispersed through standard military accounting procedures. And most damningly, they required prisoners. Specific numbers, selected by criteria Rascher provided. Requests went through Himmler's office. Approvals came back on official letterhead. Every transaction generated paperwork, memos, requisition forms, budget approvals, transfer orders. When Allied investigators arrived at Dachau in April 1945, they found filing cabinets full of this bureaucracy. Not hidden, not destroyed. Filed alphabetically. The lead investigator, a U.S. Army major named Leo Alexander, was a neurologist and psychiatrist. He'd been tasked with collecting evidence of medical crimes for the upcoming trials. What he found at Dachau exceeded anything he'd anticipated. Alexander later testified that the records showed a complete perversion of medical science, conducted with administrative efficiency that would be impressive if it weren't horrifying. The files included correspondence between Rascher and senior Luftwaffe medical officers discussing experimental protocols, letters from Rascher to Himmler requesting additional prisoners, noting that previous subjects had expired during testing and replacement subjects were needed to complete the research, replies from Himmler's office approving the requests, bureaucratic language, clinical, no moral hesitation. One letter dated January 1943 is particularly damning. Rascher writes to Himmler describing preliminary findings from the freezing experiments. He notes that survival rates are lower than expected, that rewarming methods are proving difficult, that more subjects will be needed. He requests 40 additional prisoners. Himmler's chief of staff responds within 10 days. Approved. Prisoners will be transferred from Auschwitz. 40 human lives allocated like laboratory equipment. That letter became Prosecution Exhibit 92. And when it was read aloud in court, you could hear people in the gallery gasp. Because it wasn't a battlefield order. It wasn't a panicked decision made under fire. It was routine correspondence about mass murder, conducted through proper channels. The prosecutors realized they had something unprecedented. They could trace the entire chain of command. They could show that these experiments weren't the actions of a rogue doctor, but a system that multiple institutions and dozens of officials enabled. but they still needed to prove that the experiments crossed a legal line, that they weren't harsh but justifiable wartime research, but crimes that warranted execution. That's where the prosecution strategy became crucial. Brigadier General Telford Taylor led the prosecution team. He'd served as assistant counsel at the May Nuremberg trials and understood how to structure evidence for maximum impact. Taylor made a calculated decision. He wouldn't try to present every atrocity equally. He'd focus on specific experiments that clearly demonstrated three things: premeditation, systematic cruelty, and zero scientific justification. The Dachau freezing experiments checked every box. Premeditation? The correspondence proved Rascher planned these experiments months in advance, securing approval, resources, and subjects through official channels. Systematic cruelty. The death toll and the documentation of suffering showed this wasn't accidental harm during research, but deliberate pushing of subjects past survival limits. Zero scientific justification? That required expert witnesses. Taylor brought in allied military physicians who specialized in hypothermia and cold water survival. These weren't random doctors. They were researchers who'd conducted legitimate studies for the U.S. and British navies during the war. One expert, a U.S. Navy commander named John Hayward, had overseen cold water immersion studies for naval aviation rescue protocols. His research used volunteer Navy personnel, strict safety protocols, and immediate termination if subjects showed distress. Taylor had Hayward review Rascher's reports. Hayward's analysis was devastating. He testified that Rascher's methodology was scientifically worthless. The variables weren't controlled. Different subjects had vastly different health conditions, body compositions, and levels of exhaustion from camp life. Water temperatures fluctuated. Immersion times seemed arbitrary. The data couldn't be reliably applied to actual rescue scenarios because the experimental conditions bore no resemblance to real-world situations where rescue attempts would occur. In other words, prisoners died for nothing. The experiments produced no usable knowledge. They were curiosity-driven torture masquerading as research. Hayward went further. He testified that his own volunteer-based research had answered the key survival questions Rascher claimed to be investigating, answered them with better data without killing anyone. You didn't need to immerse prisoners in ice water for 90 minutes to learn that humans die when core body temperature drops below 80 degrees. That was already established medical knowledge in 1942. What Rascher was really testing wasn't survival thresholds. It was how much suffering a human could endure, how long death could be observed and measured, what happened at the absolute limits of physiological collapse. Research for its own sake, academic curiosity backed by unlimited human subjects who couldn't refuse. That testimony destroyed the defense's primary argument before they even presented it. December 9th, 1946. The trial officially begins. 23 defendants sit in the dock. 20 are physicians. 3 are SS administrators who facilitated the experiments. The lead defendant is Dr. Karl Brandt, Hitler's personal physician and the highest-ranking medical official in Nazi Germany. Next to him sits Rudolf Brandt, no relation, Himmler's chief of staff who handled the administrative coordination of camp experiments. Also in the dock, Dr. Siegfried Handloser, chief of the Wehrmacht Medical Services, Dr. Karl Gensken, chief physician of the SS, Dr. Joachim Rogowski, head of the Waffen-SS Hygiene Institute. These aren't low-level camp doctors. These are the architects of the system. Only one defendant is conspicuously absent. Sigmund Rascher, the doctor who actually conducted the Dachau freezing experiments, is dead. Executed by the SS in 1945, not for the experiments, but for personal corruption and fraudulent research claims unrelated to Dachau. His absence creates a prosecution problem. They can't put the man who actually immersed prisoners in ice water on trial. They have to prove that the men sitting in the dock, senior administrators, medical bureaucrats, policymakers, are responsible for murders they didn't personally commit. That's where the paper trail becomes essential. The prosecution's opening statement lays out their strategy. They're not arguing that these defendants operated the immersion tanks. They're arguing something more fundamental, that they created and maintained a system where such experiments became possible, acceptable, routine. Taylor begins with a simple premise. In any legitimate medical research, there are safeguards: ethics review, peer oversight, the ability of subjects to withdraw, legal protections for human participants. The Nazi medical establishment systematically eliminated every single safeguard, and the men in the dock participated in that elimination, knowingly and willingly, because it advanced their careers and served state interests. To prove this, prosecutors present the evidence in layers. First layer, the experiments themselves, what actually happened at Dachau. They enter dozens of Rascher's reports into evidence. The court hears clinical descriptions of men dying in ice water, time to unconsciousness, heart rate deterioration, the exact temperature at which human muscle tissue begins to fail. They show photographs, men strapped in tanks, bodies being removed, autopsy tables. The courtroom goes silent. Several defendants look away. Others maintain blank expressions, as if reviewing unremarkable data. Second layer, the approval chain. Who knew, who authorized, who facilitated. Prosecutors present the correspondence, letters from Rascher requesting prisoners, approvals from Himmler's office, budget allocations from the Reich Research Council, equipment requisitions approved by Luftwaffe Medical Command. Each document has signatures, dates, official stamps. They trace the chain. Rascher reports to Dr. Siegfried Ruff at the Aviation Medicine Institute. Ruff reports to Dr. Hipke, Chief of Luftwaffe Medical Services. Hipke coordinates with Wehrmacht Medical Command. Wehrmacht coordinates with SS Medical Services. At each level, someone signed off, someone approved, someone knew. Third layer, the normalization. How this became acceptable within German military medicine. Prosecutors present evidence of the October 1942 medical conference, where Rascher presented his findings. 95 German aviation medicine specialists attended. Rascher described the Dachau experiments in detail, showed survival data, discussed methodology. Conference minutes record that several attendees asked follow-up questions. Some requested copies of his data for their own research. A few suggested modifications to improve experimental protocols. No one objected. No one reported it. No one questioned whether using concentration camp prisoners without consent might be, perhaps, problematic. Because by 1942, that question wasn't being asked anymore within certain circles of German medical research. The answer had been settled. Prisoners were available. Military needs were urgent. Traditional ethics were peacetime luxuries. The tribunal hears testimony from Dr. Franz Blaha, a Czech physician imprisoned at Dachau from 1941 to 1945. Unlike other survivor witnesses, Blaha was forced to work in the camp medical facilities. He saw the experiments from the inside. Blaha's testimony is measured, precise, professional. He describes the selection process, prisoners told they were going to light work duty, their confusion when they arrived at the medical building, their terror when they understood what was about to happen. He describes hearing screams from the experiment area, screams that lasted for hours. Guards told him those were the sounds of medical procedures. He describes performing autopsies on prisoners who died during the experiments, bodies showing massive hypothermia damage, frozen tissue, cardiac rupture, pulmonary hemorrhaging. And then Blaha says something that shifts the atmosphere in the courtroom. He testifies that Rascher and his team showed excitement during successful experiments. When a prisoner survived an extreme immersion time, they celebrated. When a new rewarming technique worked, they discussed publishing the results. They treated death as unfortunate data loss, survival as scientific breakthrough. Human suffering as methodology. Defense attorney Dr. Robert Servatius cross-examines. He asks Blaha if he's certain about the researcher's attitudes, whether years of imprisonment might have colored his perceptions, whether he's exaggerating. Blaha's response is calm and devastating. He's a physician. He understands medical research. He knows what ethical research looks like. And what happened at Dachau wasn't research. It was systematic murder with a laboratory aesthetic. The defense has no effective counter. Because everything Blaha describes is supported by the documentation, prosecutors have already entered into evidence. Rascher's own reports describe successful trials and promising results. His letters to Himmler express enthusiasm about preliminary findings. His conference presentation frames the work as groundbreaking contribution to aviation medicine. These men didn't hide their crimes because they didn't think they were crimes. And that's what makes the tribunal's task both simpler and more horrifying. The evidence isn't ambiguous. The documentation is complete. The question isn't what happened. The question is whether what happened constitutes a capital offense. The defense begins its case in February 1947. They have three main arguments. First, military necessity. Germany was fighting a total war. Luftwaffe pilots were dying of hypothermia. The research, while harsh, served legitimate military medical purposes. Second, scientific precedent. Other nations had conducted ethically questionable research during wartime. The defendants were following established norms, not inventing new atrocities. Third, following orders. The defendants were military medical officers. They operated within a command structure. Refusing orders would have been insubordination, possibly treason. The prosecution dismantles each argument systematically. Military necessity? Irrelevant when the methodology guarantees deaths that could be avoided. Allied researchers answered the same questions using volunteers and safety protocols. The choice to use prisoners wasn't driven by necessity. It was driven by convenience, scientific precedent. Name one example of legitimate medical research where subjects were deliberately killed and the deaths documented as experimental outcomes. The defense can't. Because no such precedent exists, following orders, the evidence shows these men volunteered. Rascher wrote to Himmler proposing experiments. Senior medical officers requested prisoner access for research projects. Conference attendees asked for data to use in their own work. These weren't reluctant participants following orders under threat. These were careerists pursuing advancement. The trial continues through spring 1947. Witnesses testify. Experts analyze. Documents pile up. But there's one moment, one piece of evidence that becomes the turning point. The moment when legal proceedings become moral reckoning. April 15th, 1947. The prosecution calls a surprise witness, not a survivor, not an expert, a secretary. Her name is Irmgard Huber. She worked in Himmler's administrative office from 1942 to 1945. Her job was to file correspondence related to medical research projects. She's 24 years old, nervous. She takes the stand and confirms her identity. The prosecutor asks her to identify a document. Prosecution Exhibit 133. It's a letter from Rascher to Himmler, dated February 17, 1943. Rascher reports that the current batch of prisoners used in freezing experiments has been exhausted. He needs 30 more subjects to complete his research. Huber confirms she typed this letter. She remembers it because of one specific line. Rascher writes, "Of the previous 80 experimental subjects, approximately 60 have expired. The remaining 20 have been returned to camp duties but show signs of permanent cardiac and neurological damage, making them unsuitable for additional trials." The prosecutor pauses. Lets that sink in. 60 dead, 20 permanently damaged, all described in administrative language, as if reporting office supply usage. Then the prosecutor asks Huber about the response. She identifies another document. Himmler's chief of staff, Rudolf Brandt, sitting in the dock 20 feet away, responding to Rascher. The reply is brief. "Approved. 30 subjects will be transferred from Sachsenhausen. Expect arrival by March 5th. The prosecutor asks Huber if she understood what these documents meant, what subjects referred to, what expired meant. She says yes. Everyone in the office knew. It wasn't hidden. It wasn't coded language. Then comes the moment that changes everything. The prosecutor asks, "Did anyone in that office ever express concern about these requests? Did anyone ever question whether this was appropriate?" Huber's answer is barely a whisper. "No, it was just paperwork." The courtroom is absolutely silent. The judges lean forward. Even the defense attorneys stop taking notes, because that answer captures something more damning than any atrocity description. It shows how murder became routine, how bureaucracy normalized mass death, how people could participate in systematic killing and see it as administrative duty. Rudolf Brandt, the man who signed that approval, sits motionless in the dock. His defense has been that he was a mid-level administrator following procedure, that he didn't understand the full implications of the paperwork he processed. But Huber just testified that everyone in the office knew. Everyone understood, and no one questioned it. The prosecution drives the point home. They present 17 more documents showing this pattern. Rascher requests prisoners. Brandt approves. Prisoners are transferred. Rascher reports results including death counts. Brandt acknowledges receipt, over and over. 30 prisoners here, 40 there. Routine correspondence about human lives treated as research supplies. The defense tries to recover. They argue that Brandt was overwhelmed with administrative duties, that he processed hundreds of documents daily, that he can't be held responsible for understanding every detail. But the prosecution has already established that the details weren't hidden. Death counts were explicitly stated. The purpose was clear. The choice to approve wasn't made in ignorance. It was made with full knowledge that approval meant death, and that destroys the following orders defense, because orders you volunteer to carry out, knowing they result in murder, aren't orders, they're choices. May 1947, the defense presents its final arguments. They make a last attempt to frame the experiments as regrettable but justifiable wartime necessity. They point to casualty numbers, German forces suffering massive losses in winter campaigns, naval personnel freezing in Arctic waters, Luftwaffe pilots dying before rescue crews could reach them. They argue that saving one German soldier's life justified the experimental death of one prisoner who was already condemned anyway. The prosecution's rebuttal is swift and final. They call back Commander Hayward, the U.S. Navy hypothermia researcher. They ask him a direct question. Did the Dachau experiments produce any data that saved lives? His answer is unequivocal. No. The methodology was so flawed, the variables so poorly controlled, that the data couldn't be reliably applied to real rescue scenarios. Allied researchers, using ethical methods, produced better, more usable information. So the prisoners didn't die for science. They didn't die for military necessity. They died because doctors wanted to see what would happen when human beings were pushed to absolute limits. Academic curiosity backed by unlimited subjects and zero accountability. The prosecution's final statement is brief. These men corrupted medicine. They took an oath to heal and transformed it into license to kill. They created a system where concentration camps became laboratories and prisoners became specimens. Some crimes are so fundamental, so destructive of basic human values, that execution isn't revenge. It's recognition that certain lines, once crossed, can't be uncrossed with prison time. The tribunal adjourns to deliberate. 6 weeks pass, July 19th, 1947. The judges return with their verdict and a legal framework that will reshape medical ethics forever. Judge Walter Beals presiding begins reading. The courtroom is packed. Press, military observers, survivors, legal scholars from a dozen countries. Everyone understands this verdict will set precedent for decades. The judgment opens with jurisdictional matters. then shifts to the core legal question. Can physicians be prosecuted for medical experiments conducted under state authority during wartime? The tribunal's answer is unambiguous. Yes. Certain principles transcend national law, military orders, and wartime conditions. The right to control your own body is one of them. No state, no military emergency, no research goal can override that right. The judgment addresses the Dachau freezing experiments specifically. The tribunal finds that these experiments lacked any justification that could excuse the suffering inflicted. Prisoners were selected because they were powerless. Deaths weren't accidental research complications. They were expected outcomes, documented with clinical precision. The researchers weren't trying to minimize harm while gathering necessary data. They were deliberately pushing subjects to extremes to observe what would happen. Testing limits, not therapies. That makes it murder, not medicine. The tribunal then establishes 10 principles governing human subject research. These become known as the Nuremberg Code. Principle 1. The voluntary consent of the human subject is absolutely essential. Not preferred. Not ideal when circumstances permit. Essential. Always. No exceptions. The judgment explains why this principle is non-negotiable, because the evidence from Dachau showed exactly what happens when consent disappears. Prisoners become specimens, suffering becomes data, death becomes a research outcome. The code continues. Subjects must be able to withdraw at any time. Experiments must avoid unnecessary suffering. No experiment should be conducted where death or disabling injury is expected. And qualified scientists must conduct the research with appropriate safeguards. Every principle directly responds to what happened at Dachau. Then comes the sentencing. 7 defendants are sentenced to death by hanging. Karl Brandt, Hitler's physician, approved and coordinated the entire medical experiment system. Rudolf Brandt, Himmler's chief of staff, processed the paperwork that turned prisoner requests into death warrants. Joachim Muragowski, SS hygiene chief, oversaw multiple camp experiment programs. Wolfram Sievers, administrator of the Anna Nerber Research Organization, facilitated experiments and preserved evidence for publication. Victor Brack organized the T4 euthanasia program that normalized medical killing. Waldemar Hoven, Buchenwald chief doctor, conducted his own experiments and facilitated others. Karl Gebhardt, senior SS physician, conducted bone and tissue experiments at Ravensbrück. The tribunal's reasoning is explicit. These men didn't just violate medical ethics, they systematically dismantled the entire ethical framework that separates medicine from murder. They created bureaucratic infrastructure that made atrocity routine. They turned do no harm into a meaningless phrase. 5 defendants receive life imprisonment. 4 receive prison terms between 10 and 20 years. 7 are acquitted, though several face immediate arrest for other crimes. The death sentences shock some observers. Isn't life imprisonment sufficient? Shouldn't these men be studied, their pathology analyzed, their transformation from healer to killer examined? But the tribunal's logic is clear and deliberate. Some crimes require the ultimate penalty not as revenge, but as recognition that certain boundaries are absolute. These men didn't make difficult wartime choices. They pursued career advancement through mass murder. They documented their crimes with professional pride, intending to publish, to gain recognition, to advance their standing in the medical community. And they succeeded, until the documentation became prosecution exhibits. The judgment specifically cites the freezing experiments in explaining why execution is necessary. The tribunal notes Rascher's meticulous records showing 9 months of continuous experimentation, 90 prisoners subjected to near freezing water, at least 60 deaths directly attributable to the experiments. Throughout that entire period, senior medical officials reviewed reports. They saw death counts, they read descriptions of suffering, and they approved continued funding, additional prisoners, equipment requests. Not one person in that chain stopped and said, "This is wrong." That systematic moral collapse, the tribunal concludes, merits the death penalty, because allowing these men to live suggests their crimes were somehow less than murder. The whitecoats and clipboards somehow diminish culpability. June 2nd, 1948. Landsberg Prison, Bavaria. The executions are carried out. 7 men who once held prestigious medical positions climb the gallows steps. Karl Brandt's last words are defiant. He claims history will vindicate him, that he was trying to help the German people, that wartime necessity justified everything. History has not been kind. The executions mark a turning point, not just in law, but in the fundamental understanding of what medicine means. The trial established principles that now govern all human subject research worldwide. Every clinical trial you've ever heard of traces its ethical framework back to these judgments. Every consent form you sign before participating in a medical study exists because of what prosecutors proved at Nuremberg using evidence from Dachau. The Nuremberg Code becomes the foundation for all subsequent medical ethics frameworks. The Declaration of Helsinki in 1964, the Belmont Report in 1979, modern institutional review boards that evaluate research proposals before they're approved. All of it stems from one principle forced into law by the evidence from those ice water tanks. Your body belongs to you, and no doctor, no matter how qualified, no matter how important the research, can use it without your informed, voluntary consent. That principle seems obvious now. In 1947, it wasn't codified anywhere in international law. It became law because prosecutors laid Rascher's reports on a courtroom table and forced the world to confront what medicine looks like when that principle disappears. But the legacy extends beyond legal frameworks. It reshaped how medical professionals understand their fundamental obligations. Before Nuremberg, medical ethics were largely professional norms, guidelines enforced by tradition and peer pressure. After Nuremberg, they became legal requirements with criminal penalties for violation. Medical schools today teach the Nuremberg Code alongside anatomy and pharmacology. Students learn that doctor isn't just a professional title. It's a moral commitment that transcends employer, state, and personal ambition. That lesson came at a horrific cost. 90 prisoners at Dachau, hundreds more across other experiments, thousands killed in the broader T4 euthanasia program that normalized medical killing. But their deaths forced a reckoning that changed medicine permanently. When you participate in a clinical trial today, researchers must explain risks in plain language. You can withdraw at any time without penalty. Institutional review boards evaluate whether the research design minimizes harm. External oversight ensures researchers can't simply pursue curiosity regardless of cost. Every single one of those protections exists because of Dachau. When pharmaceutical companies test new drugs, they can't simply find vulnerable populations and experiment without consent. When universities conduct psychological research, they can't deceive subjects about what's actually being studied. When hospitals test new surgical techniques, they can't skip informed consent because the surgeon thinks they know best. All of that is Nuremberg's legacy, but there's a darker aspect to this legacy that few people know about. A moral question that haunted investigators and ethicists for decades after the trial. What do you do with the data? Rascher's freezing experiments, flawed as they were, generate information about hypothermia that didn't exist elsewhere. Information that theoretically could save lives in cold water rescue scenarios. Should that data be used, published, cited in legitimate research? Or does using it validate the experiments? Does it suggest that prisoners died for something useful when the entire point of the trial was to establish that they died for nothing justifiable? This debate raged through the 1950s and 60s. Some military researchers quietly consulted Rascher's reports. Others argued that using Nazi data was morally unconscionable, that it turned victims into unwilling contributors to science they never agreed to participate in. The consensus that eventually emerged: the data should be preserved for historical and legal purposes, but never used to advance medical knowledge, because using it suggests the experiments had value. And the moment you suggest that, you crack open the door to justifying similar experiments under different circumstances. The principle had to remain absolute. Human subjects require consent, no exceptions, not even if refusing to use existing data means missing opportunities to save lives. Because the alternative is a world where researchers can weigh lives against knowledge and decide that some people's consent matters less than others' survival. That's the world the Dachau experiments created. That's the world the Nuremberg Tribunal ended. Today, every major medical institution has ethics committees reviewing research proposals. Every clinical trial has oversight boards monitoring for adverse events. Every research publication requires statements confirming that subjects gave informed consent. That entire infrastructure exists because 7 men walked up gallows steps in 1948. Their executions weren't revenge. They were a line drawn in permanent ink, a statement that medicine has boundaries, and crossing them carries the ultimate penalty. The freezing experiments at Dachau weren't the most widespread Nazi medical atrocity. They didn't kill the most people, but they became the legal centerpiece of the trial because the evidence was undeniable, the documentation complete, and the moral bankruptcy absolute. Rascher's meticulous records, the reports he filed with professional pride, the photographs he took to document his findings, all of it became the foundation for a legal framework protecting billions of people who will never know his name. That's the final irony. Rascher thought his documentation would secure his scientific legacy. Instead, it secured protections against everything he represented. Every time you sign a consent form before a medical procedure, you're seeing Dachau's legacy. Every time a researcher has to explain risks before you participate in a study, you're benefiting from what prosecutors proved in that Nuremberg courtroom. Every institutional review board, every ethics committee, every protection you have when you walk into a hospital exists, because judges looked at those reports and said, never again. Not the suffering, not the deaths, not the bureaucracy that made murder routine, not the clinical detachment that turned human beings into data points. Never again. That's what the freezing experiments at Dachau ultimately created. Not scientific advancement, not military medical knowledge, but a recognition that some lines are absolute, that medicine without consent isn't medicine at all, that no emergency, no military necessity, no potential benefit justifies reducing human beings to experimental material, and that crossing that line, documenting it with pride, processing it through bureaucracy, treating it as routine, merits not imprisonment but execution. Because some crimes don't just harm individuals, they corrupt entire professions. They destroy the foundations of trust that make civilization possible. The doctors at Dachau committed that crime. The tribunal at Nuremberg ended it, and the framework they established protects you every single day, whether you know it or not. That's the moment the judges finally had enough. Not a single dramatic revelation, but the accumulated weight of evidence showing that medicine had been transformed into murder, that bureaucracy had normalized atrocity, and that the men responsible documented everything because they thought they were doing science. They weren't. They were crossing a line that, once crossed, required the ultimate response. And because of that response, because of those executions, because of that legal framework, medicine today has boundaries it cannot cross. Those boundaries exist because of what happened in Nuremberg when prosecutors opened files marked Dachau medical experiments. And they exist because 7 men in white coats became 7 names on a gallows list. So here's my question for you. Do you think the death penalty was the right response? Or should these doctors have received life imprisonment instead? Where's the line between justice and revenge when the crimes are this systematic? Drop your thoughts in the comments. I read every single one, and I'm genuinely curious what you think. And if this deep dive into primary trial documents and legal history is the kind of content you want more of, make sure you're subscribed. We've got more Nuremberg trials, more war crimes tribunals, and more moments where the world had to decide what justice actually means. I'll see you in the next one.